Hi, my name is Megan Douglas, and I'm an attorney with Lyda Law Firm's Denver office. Today, we're going to be talking about whether or not you need a notary to make your wills and advance medical directives valid. So, let's get started. So the short answer is no. In Colorado, both a will and advance medical directive will be considered valid without having them notarized as long as you have two witnesses witness and sign each document. Nevertheless, it is generally recommended to still have them notarized as well, just because this could prevent disputes and issues down the line. But let's break this down into a little more detail for each document. So for an advance medical directive, signing in the presence of two witnesses or a notary will make it effective. If you use two witnesses, they must be over the age of 18 and they must be considered uninterested. So for our purposes, uninterested just means that they can't be a physician or an agent that you've designated to make your healthcare decisions for you in your medical directive. They can't be a beneficiary under your will or someone who would otherwise benefit from your death. For a will in Colorado, on the other hand, your witnesses do not have to be uninterested. They can be related to you or a beneficiary under your will. However, it's still recommended that you use uninterested witnesses, just because using an interested witness could lead to questions and disputes regarding undue influence or the validity of your will during the probate process. So for this reason, even though you can use interested witnesses, it's recommended that you use two uninterested witnesses. Also, while a will does not require signing in the presence of a notary, this is something that's also recommended. Colorado allows the use of what's called a self-proving affidavit to make your will self-proving. So this does require a notary, but it will ultimately speed up the probate process in the long run. Without having this self-proving affidavit, the court may need to actually get in contact with the witnesses that signed after you pass away to make sure that the will was valid. But with a self-proving affidavit attached to your will, making it a self-proving will, you can avoid this step and avoid some added time in the process later on down the line. So to make your will self-proving, you just have to sign a self-proving affidavit in the presence of a notary and two witnesses. So although our firm is currently working remotely to comply with rules and recommendations in light of COVID-19, we are still available to assist with preparing your wills, advance medical directives, and other estate planning documents. We are setting up systems to virtually witness and e-sign these documents so that they can be properly executed, and we can also assist with connecting clients to mobile and traveling notary services that will actually come directly to you. So please don't hesitate to reach out if you have any questions at all about this, or if you'd like to talk in more detail about our services. I know this has been kind of an interesting time for a lot of us, but we'll continue to learn and adapt so that we can keep providing services to those who need it. Thanks for watching, and feel free to leave any comments or questions down below or reach out to us directly.